Call to order the August 15, 2017 Board of Commissioner meeting. Please silence cell phones, pagers, and other electronic devices. Agendas are located at the back of the chamber if you need an agenda. First, we'll have a moment of silent reflection, and then the Pledge of Allegiance by Commissioner Buskard.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
First, we'll have the review and approval of the agenda. Do we have a motion?
Move for approval.
Moved by LaCroix,
Second.
second by Commissioner Buskard. Any discussion? All in favor say aye.
Aye.
All opposed, motion carries. Ms. Hawley.
Good morning, Commissioners. Holly Hennies, Commission Office Manager. For public notice, the Board of Commissioners uses a consent agenda to act on non-controversial and routine items. The consent agenda is acted upon by one motion and vote of the Board. Items may be removed from the consent agenda and placed on the regular agenda at the request of a board member or a citizen. Today's consent agenda contains the following items. Approval of the minutes from the regular meeting of August 1st, 2017. To approve the 2017 County Achievement Award submission and resolution for the Veterans Protocol Court and affix the chair's signature. Number 7 is to approve the third quarter 2017 state and local agreement with the state of South Dakota submitted by Emergency Management. Number 8 is to approve the chair's signature on the 2017 Emergency Management Performance Subgrant Agreement, Amendment Number 1, as submitted by Emergency Management. Number 9 is to authorize the purchase of road salt from Nebraska Salt and Grain per state contract number 17115 as submitted by Highway. Number 10 is to approve the Game Fish and Parks Agreement for the Hilltop Parking Lot snow removal and mowing as submitted by Highway. Number 11 is to recognize and thank the volunteers for the month of July 2017 as submitted by Human Resources. And finally, number 12 is to declare one quantum universal weight machine as presented as surplus for the purpose of donation as submitted by the Sheriff's Office.
Thank you, Ms. Hawley. Is there anyone from the public that would like to speak on our consent calendar from item 5 through 12 today? Is there any commissioner that would like to pull item 5 through 12 today on the consent agenda?
Madam Chair,
Commissioner LaCroix.
item 6, maybe we can get a review from
Okay,
Barry.
okay. Any other items, 5 through 12? Can we have a motion for 5, 7, 8, 9, 10, 11, and 12?
Move for approval.
Moved by LaCroix, second by Buskard. Any other discussion? All in favor say aye.
Aye.
All opposed? Motion carries. Item 6, Commissioner LaCroix.
Okay. Thanks, Barry. Sorry I cut you off guard. I was just, since we stream the shows or the commission meetings, I'd like to have a little brief on your presentation for the Veterans Protocol Court that you're submitting.
Sure.
For the
So, Veterans Court, and just a little overview on this, or Veterans Protocol Court, that was initiated out of the Veterans Service Office starting in about 2011. The Veterans Service Officer at that time had saw an increase in the number of veterans in our county jail, and so he took the proactive approach and started going over to the jail. The sheriff allowed him to start visiting veterans inside the jail, and a conversation kind of evolved out of that, and that information was brought forward to the Criminal Justice Coordinating Committee meeting, which has been instrumental with MacArthur Foundation as well. And we started talking about the possibility of a Veterans Court in Pennington County. Senate Bill 70 had really initiated veterans courts across the state of South Dakota, and over the years, we've hoped that money would be allocated towards Veterans Court in Pennington County. It has not to this point, but we've had a group of dedicated volunteers who started the Veterans Protocol Committee, which was kind of an exploratory committee to look at how Veterans Court could be function within Pennington County. So fast forward to last March, the first participant, and I should back up a little bit, is the Seventh Circuit. Judge Davis and then Judge Fifely were supporters of Veterans Protocol Court and really have had a judge donate his time, Judge Hieronymus, to oversee the court. And then there's been this strong team. And so I think it's important for other counties to know that this is a huge partnership between citizens in our community who have really been part of this Veterans Protocol Committee for 4 years, who have come. We used to do monthly meetings, and now that Veterans Court started in March, we don't find that necessary as much anymore because of the team meeting. But it's we have representatives from all different facets of the community, and I think it goes to show that collaborative efforts, you know, we can achieve things, and we're still hoping that the state allocates some money towards this. And actually, starting tomorrow through Friday, the Bureau of Justice is doing a Veterans Court training. So this is really an official training. It took about a year to work through this process, but the Veterans Court team is going through this training, which really provides a foundation and backbone to making this an official recognized court. So we call it Veterans Protocol Court at this time because eventually it will become really a state certified or sanctioned specialty court.
Nice.
It's my long-winded answer for you.
Any other questions? Commissioner LeClaire?
Thanks, Barry.
Sure.
Appreciate it.
Thank you, Barry.
You bet.
Your team always does a good job, thank you.
They do an awesome job.
They do. Do we have a motion on item 6?
Move for approval.
Moved by LaCroy, second by Commissioner Buschert. Any other discussion? All in favor, say aye.
Aye.
All opposed, motion carries. That's the end of the consent calendar. Now we're on regular agenda items. 13 is a lien release request.
Hello.
Hi, how are you, sir?
Good, Alan Smoot. I represent Mr. James Bialotta. We're asking for a lien release against this specific real property, and I'll kind of go, some of you may be familiar with the tax deed procedure. I'll try to make this as quick as possible, but basically, Mr. Bialotta went to the county treasurer's office and purchased the tax sale certificates. And I don't have the amount in front of me. I think it's like $9,000 something. Whatever the taxes were due, the treasurer would not give that tax deed until all those taxes were paid. So he paid the taxes. And then as part of the tax deed procedure, in order to, he is to give a notice of intent to take tax deed to anyone who shows up on a title search as a lien holder. And there were I believe three credit collection agencies that were lien holders. The county also had, looked like a county assistance lien, I think sometimes referred to as a county poor lien, that was on the title search. So we proceeded to give notice under the statute for the tax deed procedure to all of the lien holders. We noticed all of the credit collection agencies. We also noticed the Pennington County auditor, according to the statute. After all those notices go out and also go out to the owner of record, there's a 60-day redemption period, and no one redeemed, including the owner of record, and Mr. Bialotta then got the tax deed. You would think that would be enough for him to go fix the property up and sell it, but it isn't. Under our title standards, and considering the title insurance companies, where you go to close, they have underwriters, insurance underwriters, and they say, we're going to underwrite or insure the condition of this title only if we feel real secure there's not going to be any liens or claims that come against the buyer later. So we have two options. One is to do a quiet title proceeding in court, which is kind of a pretty good expense for the client. So those title underwriters will be happy by seeing a court order that says this title is quieted. Even though all the liens have been stripped and are unenforceable against this specific real property, that's what they want. The other option that the title insurance underwriters for the title companies will accept is that we get a written lien release from anyone who had a lien against that title originally, even though that lien's already been stripped and unenforceable. So we went to the 3 credit collection agencies. They recognized that their lien had been stripped, and they signed what I referred to as a partial release against specific real estate. That means that this real estate that Mr. Bialotta now owns has no liens against it. However, those liens are still in full force and effect against that particular record holder who originally owned the title for any other property, any other title property in Pennington County. So we understand that the only procedure, we can't just I tried to send that to the auditor, and she says, I don't know what's going on. So then I did visit with Mr. Alderman, and he said about the only way to get a lien release through the county is to come to the county commissioners, and that's why we're here today. I asked him for that, and I'm open for any questions.
Any questions from the board?
My only question would be for Jay is the conversation and the legality of this.
I'm sorry, I missed that.
The legality of what's going on with this, because it is kind of confusing when you're reading through.
Tax deeds are confusing, but once you've worked with them for a while, it makes a little bit more sense. And so the first, Jay Alderman with the State's Attorney's Office. First thing I'd like to say is Mr. Smoot explained it very well, but of course, yes, it's still confusing. The reality of it is when a tax deed is issued under 102512 is the statute in South Dakota, it says you get a fee simple title to that property except for any city special assessments and state liens, meaning state of South Dakota. Everything else is wiped off. And as Mr. Smoot explained, a different section of the code called the marketable title standards says that even though that's the case, underwriters, title companies won't want to warrant or give a warranty deed on property if all you're holding is a tax deed to that property, even though that statute says all of that. So you have to go through these additional steps. And Mr. Smoot has gone through these additional steps, and so what I would call at this point right now as we stand here, it's a formality. The lien that he's asking you to release is already gone.
That's right.
But he's wanting a paper trail that he can use to give to the title company where they will go, thank you, appreciate you did that, now we'll go forward with it. That's all this is. The lien that was created originally is still against that person, and that person, if they ever acquire any additional property, will automatically attach to that. So we haven't lost that lien only against this particular piece of property, and it was legally lost, as was explained. So I've reviewed it and consulted with Mr. Smoot, and I totally agree and understand and would recommend that you approve the release.
Thanks, Jay, because that's, as I was reading through the transfers and all that others, yeah,
It is confusing.
yeah, because it's like even at the end, you made the comment that, yes, but there was no actual thing that it was released, you need the paper for.
Exactly. We're asking to put on paper what's already been released just because of the
Yeah.
title insurance underwriters.
I'd make the motion to approve.
Second.
Been a motion to approve and a second. Any discussion? All in favor, say aye.
Aye.
All opposed, motion carries.
Thank you.
Thank you, sir. Number 14 is another lien release. Jay?
Good morning.
Again, Jay Alderman with the State's Attorney's Office. Another very confusing matter that you're about to hear, and I'm here to help try to explain the law and the basis for everything. But one of the parents in the matter who has a lien against her is present here today, and I know she wanted to address you. The father or the other parent is not present today, if I understand it. And that's a matter you may want to discuss, but I'll stand by.
Okay, thank you.
I'm just asking for this lien.
Just your name first time.
I'm sorry, Carla Barber.
Thank you, Ms. Carter.
I'm just asking for this lien request because the matter that happened over 5 years ago, 6 years ago. It was a matter between my daughter and her dad and I. I took care of my half of it. In fact, I paid more than half in December 2012. And I thought it was, because I was told back then it was split equally between the parents. So I paid my half right away. I just found out 4 weeks ago, or less than that, 3 weeks ago, that my daughter's dad is trying to get me to pay the other half as well. And I don't think I need to, because I took care of my half right away immediately. As I've shown in documents, I've also supported you. He just does not like to pay bills. And so he's trying to put this off on me. And the statutes say that it should be split equally between the parents, and that's what I was told in December 2012. That's why I only paid half. But I actually paid a little bit more than half, about $56 more than half. So I'm just asking for it to be put in his name instead of my name, in his name.
Thank you.
Thank you again, Jay Alderman. All right, so what this involves is, and I explained to Ms. Barber on the phone that it involves a matter of what's referred to as abuse and neglect, okay? And I explained that if she seeks a release today, some of this detail has to come out even though it's otherwise considered privileged. But there's no way to really come before the county commission and have a blunt and thorough conversation about these matters without going into it in some level of detail. So here we are. The child was removed from Miss Barber's house due to an incident, and as I understand it, was placed for that period of time with the father. Correct me if I'm wrong.
Department of Social Services and then with Dad.
Right. Our office then brings a petition into court for abuse or neglect. And that can go to a hearing and have a court trial, and there can be what's called an adjudication. It's not a finding of guilt. Under the statutes, when you have an adjudication in an abuse and neglect proceeding, it's called you're adjudicating the status of the child. It's not necessarily, and it uses literally those terms in the statute, an adjudication of the relative fault of one parent or the other. It's the status of the child. If there's no adjudication, the county gets no lien. In this particular case, there was an adjudication, okay? Which means the child had an attorney, and that's mandatory in abuse and neglect proceedings. It's not mandatory in other juvenile proceedings. It is an abuse and neglect. So attorney was hired, attorney generated some bills, got paid for his or her service, and the county has a lien. Not just a little bit more background. In other juvenile proceedings, there's a cap of $1,500 on attorney's fees. Not true in abuse and neglect proceeding. Our state statute says there's no limit. So it could be thousands of dollars, certainly more than the $1,500 cap for other juvenile delinquency or CHINS proceedings. A&Ns are treated differently. Statutes also provide that the parents, without distinguishing relative fault between them, you bring a child into this world as a husband and wife, you're a parent, you're both, it says, jointly or severally liable. It doesn't say that you automatically just split it 50-50. So the point is that both parents' names would go on the lien statement, and whether they're separated or not, they're a parent. And then you'd have the total dollar amount. And it's just figured out from there. One parent can pay it all. They can decide to split it amongst themselves. One can pay it and then I suppose seek contribution from another in a court of law. But they're jointly and severally liable. So they can be liable for part of it or all of it. So having said all of that, in this case, factually what happened is the respondent mother, who's standing here before you today, paid approximately 50% or maybe slightly over, as you just said, 50%, which would leave 50% of that bill, if you will, setting out there, technically under both parties' names. The respondent father didn't want to pay any of it because he didn't feel he was part of the incident giving rise to the lien in the first place. Our statutes don't recognize relative fault. They just say if you're a parent, you're on the hook. So the question before you today, technically, is do you decide amongst yourselves today that Miss Barber has paid enough and that the dad ought to pay the other half? Or should both of their names be on the lien statement for the remaining half and let them figure it out? Or any other combination thereof? That's really the question before you today, because both parents are jointly or severally liable for the entire amount.
Thank you, Jay. Any
May I
questions?
say one more thing?
Yes, ma'am.
I'm sorry. Back in 2012, when I heard about this lien, my attorney was Jane Fifley. She is now a judge. She and Wendy McGowan, who is my daughter's attorney, and a few other people told me at that time that I only had to pay half. If I was liable for all of it, I would have paid for all of it, because back in 2000, just a month and a half later, my sons, who are both captains in the Army, we were buying a property, and I had to pay off this lien in order to purchase this property with my two sons. I was only told I had to pay the amount that I paid, which was $12.43, and then another $56 I paid another 2 weeks later, bringing it to a total of $13.05. I was never told at that time that I was responsible for all of it. In fact, everybody told me I was only responsible for half of it, so that's all I paid. This has just come before me in the last couple weeks that I'm now still on the other half. Otherwise, I would have paid it a long time ago, just because, and since then, we have bought a few other properties, and this has never come up. The only reason this came up was a couple weeks ago, my daughter's dad walked into the auditor's office and said, "You need to put this in the mother's name," and they did without even consulting me. And then I contacted them and said, "Why is this?" And anyway, so that's why we're here right now.
Yes, ma'am.
Thank you.
Any questions?
Madam Chair,
Commissioner
I don't
McCray?
really have any questions 'cause without digging deeper into the incident. I mean, it seems like a pretty tough, you think it's a cut and dry 50-50 deal, but without the whole picture of how it all started out and why, and the father not being here either. You have full custody, right?
Well, my daughter's 19, but
She's
yes.
19 now.
Well, we had joint custody. We had
Okay.
joint custody, but she's 19 now, so. But as you can see, I mean, I did put that into evidence that her dad still owes me $2,600 in back child support. He doesn't even pay $25 a month. He will be paying that until she's 30 years old. He just does not pay his bills. You know, I've been fighting for child support since she was 14 years old, and he still owes me quite a bit.
I read through the paperwork you brought forth, and I understand where you're coming from. So
Yeah.
that's why I'm just kind of struggling. I didn't know if anybody else on the commission had any more comments on this.
I have something. The father was involved, the man that's paying paying the half. Jay had said one thing, this father wasn't involved in the incident. He's just the father of the child,
He's the father of the child.
but he
yeah.
wasn't involved in the incident that got her taken away.
No, he wasn't involved in that incident, but he okay, just a little bit of extra. She was removed from my home. I did spank her once. It was ridiculous, you know, I spanked her once. She was removed from my home. I have two other children, like I said, my sons are both captains. I each spanked them once at one point. Anyway, in the process of her going into his house, she dropped out of high school. She has an 8th grade education. She never even went to high school. With me, she was getting good grades. She was playing the violin, and she was in gymnastics. He let her drop out of everything. She has gotten pregnant when she was 16. I have a 2.5-year-old granddaughter. She is just now at 19 years old finishing her GED. If she would have stayed with me, and this was a huge battle, she would have been pretty much like my sons. Finished high school, she'd probably be in college right now. And so her life took a definite turn just by me spanking her once and then removing her from my home. Because her father's dad has 4 other children as well from her dad and I were never married. from previous women. None of them have graduated high school.
Okay, thank you. Any other questions?
I'd sure like to hear his side. Why-
I'm sorry, what?
Not that I don't believe what you're saying, ma'am, but I think I need more information to vote.
You guys need a continuance, or are we ready to vote? What's the motion?
Well, I'm the only one that hasn't said anything, I guess. I normally would say that the law says you owe the money, and I'm sorry about that. In this case, I think that there's a deadbeat dad involved, and I think that he owes some money. And we should go after him and get the money. How we can do that, I don't have any idea, because if they don't pay, they don't pay. But
Can we put his name on the lien?
What you
And
could
take
do
hers
is
off?
you could remove the respondent mother's name from the lien at this point and have the remaining dollar amount be in his name only.
then
And
he-
that's what, and the auditor would
That's all I'm
produce
asking.
that statement and record it with the Register of Deeds.
It's not exactly the way the law reads, or probably should be interpreted, but I have no time for deadbeat dads that don't want to take care of the kids that they spawned. So,
You have a motion.
that's a motion to take this lady's name off the lien and go after him with every gun we have.
Motion by Buschard,
Second.
second by Commissioner LaCroy. Any discussion on the motion?
I'm going to abstain because I don't have enough information, not that I don't trust this young lady, but there's typically another side, and we're not hearing the other side, so I'll have to abstain.
Okay. All in favor, say aye.
Aye.
Aye. All opposed?
Abstain.
One abstention. Motion carries.
Thank you very much.
Now, you should take him to court and try to, maybe you already have, to get that money. He owes you the money.
Yeah, well, it is,
Trouble is, you'll spend all that money on attorney fees, but
yeah, thank you so much.
Thank you, ma'am. Have a good day. Item 15 is public hearing, general fund operating transfer, SP 17-009 to Healthcare Trust Fund. Ms. KJ Peterson.
Good morning, KJ Peterson, Chief Deputy Auditor. The board may recall at the, I think it was the 18th of July meeting, during the exit interview from Bruce Hans from the Department of Legislative Audit, there was a correction that need to be made in the proper accounting of the interest earned for the Healthcare Trust Fund as it relates to the distribution of grant funds. The amount was for 2016 was rather minimal, but in order to get that corrected, that $2,304.08 that currently is sitting in the general fund should be transferred back to the Healthcare Trust Fund. We, at the last meeting, on the consent agenda, corrected the future distributions for accounting purposes beginning in 2017, so that we'll leave those funds directly in the Healthcare Trust Fund as they earn interest. So this, again, procedurally is to supplement the budget and then subsequently transfer the $2,304.08 back to the Healthcare Trust Fund. I believe the motion is to approve the supplement for the operating transfer and authorize the transfer in that amount from county general unassigned reserves to the Healthcare Trust Fund to properly account for 2016 interest earnings.
so we put the interest in the general fund and it shouldn't have been.
Yeah, we actually have done that for the last couple of years. In the whole course of accounting, we always take all the interest earnings from county funds. We distributed them properly to account for them in each fund. We used to keep that money in the Healthcare Trust Fund. We changed the policy 2 years ago. Interest earnings had gone down so much, the amount that we were actually moving around was pretty insignificant, therefore the $2,300. But because of the fact that there are employees whose contributions from the employer healthcare match is also partially funded by grants. We need to keep it in the fund.
Do we have a motion?
Move for approval.
Moved by LaCroy,
Second.
second by Buschert. Any discussion? All in favor, say aye.
Aye.
All opposed, motion carries. Ms. KJ, the alcoholic beverage transfer of Sugar Shack to Sugar Rush.
This is the application for the transfer of retail on-off sale malt beverage from the Sugar Shack LLC to the Sugar Rush. Obviously, the same location, new business owners, and fees have been paid, and everything has been presented to planning and zoning and law enforcement with no problems there.
Thank you, Ms. KJ. Do we have a motion?
Move for approval.
Moved by LaCroy,
Second.
second by Buschert. Any discussion? All in favor, say aye.
Aye.
All opposed, motion carries.
Thank you
Members-
very much.
Thank you, Ms. KJ. 16A, reconstruction of North Deadwood Avenue. Mr. Wilson.
Good morning, Tom Wilsey, Pennington County Highway Department. Reconstruction of North Deadwood Avenue. This is a project that has been in the works for about 8 years now. It's going to be a joint project between the county and the city of Rapid City. We have 0.56 miles of road between Meade County and the city of Rapid City. We are looking at reconstructing that section with the city for their section down to I-90, the I-90 exit at Deadwood Avenue. There is a corner right in our section right there where we have had 20 accidents since 2010. And it's a very unsafe corner. The idea is we're going to put this road on the section line, straighten the road out, and hopefully avoid more of those accidents. Right now, we are going to let the city, we've had a meeting with the city, they are going to do the hiring of the consultants for this. That'll be about a 3-month process through them, at which time I will probably come before you again saying what that will end up costing. They have a little different process for hiring than we do. So right now, the motion I am requesting is a motion of support for this project for the construction of the half mile of North Deadwood Avenue between the city of Rapid and Meade County.
Thank you, Mr. Wilsey. Is there a motion? Discussion, Commissioner Fairby?
Is the section line, I'll back up, obviously there's a curve in the road. Is the Meade County on the section line, or are we in the section line, or is it a correction?
The Meade County section is on the section line. Right
We're
where
gonna move all the road over to the section line, or is there correction in there?
there is a, I gotta put this in,
Yes.
get the pictures. I can
Oh,
show you
yeah.
better with this.
Okay.
Good,
I know this was a long time coming because since I've been on the city council, that area has had issues, and I've had a lot of clients talk about that road and that corner.
the
So-
road's absolutely horrible, but
Yeah,
Yeah, the city section,
the curve can't go away if it's a section line correction.
let me get this picture up. I can show you a
Okay,
lot better
all right,
with
good.
a better discussion that way.
And how that road onto my district, I don't know, but but it is. I've had Meade County people call me about the road. Do you know what we're talking about?
I know where
It's
Deadwood
rough.
Avenue
It's
is.
rough.
it's bad. That
Our-
curve's
our
been
part's-
bad for a while.
Our part's not bad,
Yeah,
but I mean, the Rapid road is rough, is really rough.
yeah, that curb is bad, though.
Got to drop that.
Yeah, I'll wait till you drop it.
TVs.
So basically, they're going to move the correction someplace else.
Okay. Play, slideshow. Okay. This is the first pictures, well, it's not up here, but the first picture is actually up in the city section. It is on the south of where the county part starts. This crest, if you look at this, you can see where the section line is. This is, if you look straight across this hill, there's a road disappearing over the hill in the middle of the picture there. The section line actually follows right there. We're gonna take these curves out and put it right straight across this valley here, this draw. If you see, look at this picture, right where the hill crests and disappears, that's about where the county section starts. It's a city section up until there.
And our part's got a curve.
We have, the first part of the curve is in the city, then the big looping curve back is in the county. If you're standing here, this is looking south from the north of those curves. We're looking right up the section line there.
Okay.
Between those two sets of power lines, that's where the section line goes.
Madam Chair.
Commissioner LaCroy.
Thanks, Tom, because, you know, from first glance, looking at this, you're looking at a half a mile at what was the cost? $1 million?
The city estimated $1 million.
Yeah.
I think that's a little strong.
But they probably added in some,
They have not put anything together,
okay.
formal estimation. They're just saying, it's gonna be about $1 million for your part, about $2 million for ours.
Okay,
Mostly they said that so that we could kind of decide how much. I'm gonna pay 1/3 of the design work, and they're gonna pay 2/3.
okay.
This is right at the county line. You can see where Meade County has rebuilt their section. What we're going to do is match their section, city and myself. This is actually a 26-foot wide top with a 1.5 to 2 foot safety shoulder off the edge. There's a little better view of the typical section in Meade County.
Nice.
Is it a little narrower than what the existing is?
What we
When you
have
look at
is
it-
22 to 24 feet.
Okay,
We will be widening it out just a couple feet.
okay.
And the safety shoulder is 1.5 to 2 foot wide and slopes out it's a recoverable shoulder is what they call it. And that's the section that the city wants to build theirs to, and that we're gonna do the same.
Any other questions or a motion?
Going to put up a toll booth for the Meade County people.
Pardon?
Going to put up a toll booth for the Meade County people to
Well,
help us pay for
they'll
them.
probably put up for all of our people going their way too.
Well, I think it's a little heavy the other way.
Do you have any statistics on cars per day?
The ADT is a little over 1,600, except during rally, which it goes up, because J&L Harley is just south of here.
Yeah. Maybe
But a normal day is 1,600, and 1,647 was our last count.
maybe Sturgis would care to throw some money in on this. They're the ones that make all the money.
Well, actually, Meade County, I mean, the residents that live north of there, then that's their way to town, to Rapid to work. I've got, like I say, a number of phone calls, but when's Pennington County going to fix the road? I went and looked at it a couple of years ago, and I said, wait a minute.
The fixing needs to be in the city.
Yeah.
We feel that we do a pretty good job of keeping our section up.
The Pennington County portion is, except for the curve, is smooth, but Rapid is rougher now. I mean, just rough. It's almost like driving Fourth. When I come into the meetings, that Fourth is just horrible.
We have a motion? Mr. Farabee?
So move.
Moved by Commissioner Farabee. Is there a second?
Second.
Second by Commissioner LaCroy. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries.
Thank you,
One
Commissioner.
last question for Tom, if I could.
Yes.
The city portion, the city is on the west, and we're still on the east. But the whole road belongs to the city, correct? But once you leave, once you go,
I don't understand what your question is.
once you go north from Jennings,
It's all in the city.
but it's county property to the east. I think it's not in the city yet, I don't think.
I believe it is.
Well,
From what I remember on Rapid Map, I believe most of it is city, both sides.
well,
Not all of it, but most of it.
but at least they're going to build that part of the road.
That's their road, yes.
Thank you.
Thank you, Tom. Thank you, Commissioner Fairby. Number 17, Mr. Kraft is not going to be here till 11. Items from planning and zoning don't start till 10:30, so if it's okay with the board, if we go into executive session, it shouldn't take too long.
That's my motion.
Motion by Commissioner Buschrood. Is there a second?
Second.
Second by Commissioner LaCroy, and that's for item B, contractual pending litigation. So,
Yes, Michelle
SD.
Hoffman on behalf of the State's Attorney's Office. That would be pursuant to SDCL 1-25-2 subsection 3 pending or proposed litigation.
thank you. All in favor, say aye.
Aye.
All opposed? Motion carries. Commissioner Fairby, all in favor, say aye.
Aye.
All opposed? Motion carries. We have a half hour before Board of Adjustment. You want to take recess for a half hour?
So moved.
Second. All in favor, say aye.
Aye.
All opposed? Motion carries. 18, items from planning and zoning, starts at 10:30. We need a motion to go into Board of Adjustment, please.
So moved.
Second.
Moved by LaCroy, second by Buschrood. All in favor, say aye.
Aye.
All opposed? Motion carries. Is the applicants here today? Okay,
Let me check.
okay. Thank you. We do have 3 items from Board of Adjustment today. In order to pass these Board of Adjustments variances, you need all 4 votes from the commission today. If you'd like them continued when you come up, because to the next meeting, because you think that you're going to need all 4 and you don't think you can get it today, then please come up and tell us you need it continued when we call your items. That's okay. Thank you. We're on item A.
Good morning, Brittany Molitor, Environmental Planning Supervisor for Pennington County. Item A is a variance request for Chase and Lonnie Phillips. The applicant is requesting to reduce the required lot size in a general agriculture district from 40 acres to 2.83 acres and 1.76 acres per a condition on a previously approved layout plat, PL 1712. As the property exists today, it consists of 4.59 acres. It appears to be legal nonconforming based on Register of Deeds records. The access is off of Highway 1416 via an existing approach. The lot contains a single-family residence built in 1969 per DOE records, a 28 by 24 detached garage built in 1945 per DOE records, and a small shed, and on-site wastewater treatment system. The applicant is proposing 2 lots. One lot would consist of 2.83 acres and still zoned general agriculture district and would require a lot size variance, which is what this request is. The lot will contain an existing single-family residence, existing detached garage, and an existing small shed and on-site wastewater treatment system. Lot 2 would consist of 1.76 acres and access would be off of 1416, and the lot is currently vacant, and the applicant is requesting this for another single-family residence. So there's a criteria for variance requests. The specific circumstances or conditions such as exceptional narrowness, topography, or siting exist. Staff has verified through a site visit that there are no particular physical conditions which warrant approval of the lot size variance, that the variance does not grant a use which is otherwise excluded from the particular district. The lot size variance would not grant a use which is otherwise excluded from property zoned as general agriculture district. that due to specific circumstances or existing conditions, strict application of the zoning ordinance would be an unwarranted hardship. Strict application of the zoning ordinance would require proposed lots 1 and 2 of Wicksville addition to meet the minimum lot size requirement of 40 acres. And finally, that the granting of a variance is not contrary to the public interest, is in harmony with the general purposes and intent of the zoning ordinance. Granting this lot size variance does not appear to be contrary to the public interest, but would allow for 2.83 and 1.76 acre lots in a general agriculture district, which is not in harmony with the general purpose and intent of the district. So staff does not make if the Board of Adjustment approves variance 1711, staff does not make any conditions, as the concerns or requirements will be addressed through the plating process.
Thank you, Ms. Brittany. Do we have the applicants here that'd like to speak?
Good morning. My name is Dean Scott. I'm the surveyor on this project. And Mr. Phillips is in the audience. We kind of agonized over this. This is actually at the Wicksville corner. The old Wicksville Church is just to the north. And as you know, this property has kind of been the same for 50-plus years. You know, we've kind of been taught that the phrase spot zoning is kind of a bad word. And I guess my experience in coming before this board for many years is that in most cases, the spot zoning concern has overridden the concern for giving the lot size variance. You may remember that recently I helped another person in a somewhat rural area with a similar thing, and you folks preferred the zoning to be changed. And in that case, there was similar limited ag zoning in the near neighborhood. This happens to be I didn't realize there was any limited ag even within a mile, but I do see in the report that there is a little bit of limited ag to the north, correct? But I guess it's not really of concern to the landowners whether it's rezoned or we get the variance. But I guess after many discussions with the landowners and with planning, we've kind of thought that maybe this is the way we should go with this one because, like I said, in my experience, I tend to recommend not rocking the boat. And this would basically be no change. What it is Mr. Phillips' grandmother is the one who lives in this house. And she has transferred the property over to Chase and his wife. And she basically has like a life estate on the property in the old house. Chase and Lonnie would like to build a house next to grandmother in the southeast corner. So I tried to draw a plat that would divide it. In actuality, the entire property right now is 3 lots. For some reason, it was platted that way in the 60s, but it's always been utilized as one piece of ground. And it's just another one of those existing non-conformings where it's always been ag, and it's just so. I guess what we're proposing is that we just kind of continue along with the same zoning. Of course, I can't tell what the future might hold, whether Chase and Lonnie may choose to sell the grandmother's house in the future. I suppose that's a possibility, but from my understanding is it's just going to stay in the family.
Any questions, board?
I guess, is the applicant okay with 4 of us voting, or does he want to wait until the 5 of us are here?
Well, we understand that it requires 4 yes votes, and we were informed that, you know, we were short a commissioner this morning, but Chase and I talked, and we thought, you know, we'd rather just go ahead and visit. We were ready. We'll just go ahead and visit with you folks, see what you folks think, and not being any more certain that the vote would be different if all of you were present. Okay. So we'll respect whatever decision you make. But like I said, I guess the reason we came in, you know, like I said, on another recent project, we came in with variance, and you folks really wanted the change. And we thought, well, maybe that's how we should go with this one too. But this one, like we said, has a lot, it's just surrounded by ag for quite a ways. And so we thought maybe not rock the boat.
Well, Madam Chair, the spot zoning thing makes a lot of sense to me, and I guess I would, on that basis, I would sure vote for it.
Is that your motion?
Is that your motion?
That's my motion, yes.
Motion to approve by Commissioner Farabee. Is there a second?
Second.
Second by Commissioner Croy. Any discussion? All in favor, say aye.
Aye.
All opposed? Motion carries.
Thank you
Thank
very
you,
much.
sir. Item B.
Good morning, Cassie Bolstead, Assistant Planning Director. Item B is variance 1712. This is a variance to reduce the minimum required side yard setback on the east property line from 8 feet to 1 foot 4 inches to construct a detached garage. The applicant here is Logan Beckett. I did have a phone call with Logan this morning. He sent me an email and he is asking for this item to be continued to the next board meeting for a full commission.
Thank you. Do we have that motion, please?
So moved.
Second.
By Buschard, second by LaCroy. All in favor, say aye.
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 All opposed? Motion carries. Thank you, Ms. Cassie.
Tell him, you when you talk to him, tell him it was a wise decision.
Ms. Brittany.
Good morning again. Item C is a setback variance, VA 1713, to reduce the front yard setback from 25 feet to 18 feet to allow for the construction of a detached garage, to reduce the front yard setback from 25 feet to 21 feet to bring an existing single-family residence into compliance, and to allow a detached garage which faces a street to be located closer than 25 feet to the street right-of-way. As the property exists today, it consists of 2.16 acres. It is zoned limited agriculture district. Plan unit development sensitive is the future land use. The access is off of Lightning Ridge Road. There is no special flood hazard area on the property. The lot does contain a single-family residence built in 1977 per Department of Equalization records, an on-site wastewater treatment system, and a 24/60 stable. This was routed through the interdepartmental review. There was no items of concern that came back. This property is located in a road district, and the property owners have gotten signatures from, I think, 4 of the members of the road district that they didn't have any concern with the setback. The criteria for a variance, that specific circumstances or conditions such as exceptional narrowness, topography, or siting exist. Through a site visit, staff observed that a significant portion of the subject properties contains mature trees. In addition, the on-site wastewater treatment system appears to be located to the rear of the single-family residence between the stable and the residence. That the variance does not grant a use which is otherwise excluded. This setback variance would not grant a use which is otherwise excluded from a property zone limited agriculture district. Garages are allowed in a limited agriculture district. That due to the specific circumstance or existing conditions, strict application of the zoning ordinance would be an unwarranted hardship. Strict application of the zoning ordinance would require the landowner to meet the minimum required setback to a property line. The portion of the subject property where the garage is proposed appears to be clear of mature trees and other obstructions, however, it does not meet the front yard setback. That granting of a variance is not contrary to the public interest is in harmony with the general purpose and intent of the zoning ordinances. Granting these variances may not be contrary to the public interest, as no one has come forward to question or object to the applicant's request. The applicant has submitted a signed by 5 of the road district members letter from the road district for the request. Staff did do a site visit. You can see in the picture on the left, actually my left, where the property or where their proposed garage is and where the existing residence is. So staff, if the Board of Adjustment does approve this variance, staff recommends 2 conditions.
Any questions, Board?
Madam
Commissioner
Chair.
LaCroy?
After reviewing this, I think they put some careful thought in. They didn't want to remove some older trees in order to put the new garage up. But this is also to bring it up to code and so forth. And so I think they took some careful thought and worked through this. And they're willing to move forward today.
If the applicants would come forward, please. Thank you.
I don't want to, she's usually asking if there's any questions from anybody in the public, so.
That's okay.
I'm Don Hollis, this is Teresa Scott. We did try to position a different building on the property prior to we knowing the 25-foot setback. And once we found that, we were in the drain field. And because of the length, depth of the property and the narrowness, it pushes everything in. And with the trees and the barn out back and the drain field, it takes up, I don't see how we can put anything other than kind of right where it's at without knocking down. I mean, that's one of the reasons why a lot of people live up in there, is because of the way that looks and everything. And we're trying to keep it the same type of look there. Otherwise, you're driving across the pasture if you put it clear back up in the southeast corner.
Yeah,
So that's the reason. And we did get, I don't know if you see it, we have a conceptual drawing.
Oh, yeah.
I mean, we did
I like
try
it.
to give as much information as we could so that way you guys can make a sound decision. I sure appreciate it.
You actually, I just got one follow-up question. You actually reduced your original size of what you were going to do, so it fit.
Yes, sir.
So it wouldn't take out any more trees or anything else.
Yes.
Correct.
Any other questions?
I would like the planning and zoning department to request and require drawings like this in all the future.
Yeah.
We tried hard.
I'm a military person, so I kind of try to take all of the check blocks.
You did well. Do we have a motion?
I want
Oh,
to
Commissioner
make
Fagan.
sure you're okay with the four of us.
Yes, sir.
Sir,
You're okay?
yes.
All right, thank you.
They obviously have not done their research and looked at my voting record on variances.
Absolutely, sir. I don't know the voting record of any one of you.
Do we have a motion?
I'd make the motion to approve with the two conditions included.
Second.
Second? Okay. All in favor, say aye.
Aye.
All opposed, motion carries.
Thank you.
Way to scare him.
Make a motion to come out of Board of Variance, Board of Adjustment.
Motion by Busker, second by Mr. LaCroy. All in favor, say aye.
Aye.
All opposed, motion carries. Next, we're on consent calendar. Miss Cassie, welcome back.
Thank you. The Board of Commissioners uses a consent agenda to act on non-controversial and routine planning and zoning items. The consent agenda is acted upon by one motion and vote of the board. Items may be removed from the consent agenda and placed on the regular agenda at the request of a board member or a citizen. The consent agenda for planning and zoning contains the following items. Item D, second reading of Major Planned Unit Development Amendment 1704 for Kelly Development, Ryan Kelly, and approval is recommended. And item E, second reading of Major Planned Unit Development Amendment 1707 for Donna and Lyle Hartshorn, and approval is recommended.
Is there anyone from the public that would like to speak on item D and C?
D&E.
E, sorry, I can't read my writing. D and E. Is there anyone from the commission like to pull anything on D and E on the consent calendar? If not, do we have a motion?
Make a motion to approve the consent calendar.
Motion by Busker, second by LaCroy. Any discussion? All in favor, say aye.
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 All opposed? Motion carries. Next is the regular agenda item, item F.
Item F is a request for approval of a building permit outside of county zoning ordinance for Scott Licht of Black Hills Nursery. This is a request to give authorization that the planning director sign a building permit that is not in conformity with the Pennington County ordinances. On June 29th, Scott Licht, owner of Black Hills Nursery, applied for a building permit for a 38 by 30 detached garage. Upon staff's review of the building permit and the property, it was discovered that there are a number of existing structures on the property that do not have building permits. It looks like he's missing approximately 9 building permits. Mr. Licht is working with staff to correct this issue. Staff has been out there on site and identified what structures need building permits. He is aware of this, and he is aware that it might take us some time to do a little bit more research to make sure we have all our P's and Q's crossed. But while he works with staff to correct the violations on the property, he is requesting two things: that the building permit that he submitted for the 38 by 30 detached garage be approved by the planning director with the existing violations on the property, and that the commissioners approve a building permit that has not yet been applied for an 18 by 20 carport. It's my understanding that the 18 by 20 carport already exists on the property, so the building permit that he would apply for that would actually be correcting one of the violations that exists. But currently that carport encroaches into a setback, but the applicant is willing to move that carport before he submits the building permit.
Is the applicant here? Come on up, sir. Commission, do we have some questions for Mr. Licht? Sir, would you like to present your case?
Like she said, I'm not, I haven't got any paperwork on what all the 9 supposed violations are. We may have some disagreement with there, but I'm more than willing to try to work things out. And I just want to be able to get started on the garage project. And
Did you
I'm
own,
doing it myself. And
Sorry.
it takes a long time when you're doing it by yourself.
did you own the properties that need the 9 building permits?
Do I
how long
own the
have those,
property? Yes. I
how
own
long
the
have those
property.
been there? Cassie?
That I don't know.
Sir, can you answer that?
On what's that? On
There's 9 properties that need building permits?
9 items, but one of them's, there's some of them I don't understand, that's what we're trying to work out. One of them was a supposed addition to a house, which that was always there. It was not an addition to the house, it's been there since the house was built. Another one that's circled is a storage shed that's under 144 square feet. Another one is a chicken house that's under 144 square feet. There are 2 carports, and there's 2 greenhouses. Try to work with it. The IRS considers greenhouses to be equipment, and they're deductible on the 179 deduction for equipment, and they're also considered temporary structures.
How long ago did you build the carports and,
Carports were put up in 2007.
okay, and you didn't know you had to get building permits for any of this stuff?
No, it's a previous commission, I'd called and said there were no regulations on them. So,
And when did you call?
Hmm?
When did you call the previous,
oh, that was
Planning.
way back in 2007.
okay.
Madam Chair,
Commissioner Gray?
thanks for some of the input, because just from the paperwork and being able to see this, now I can kind of understand some, when you hear 9, it's a little setback, but like you said, if some of them were the sheds. The carport, I would probably question too if I was putting one up. I mean, really, sometimes you think, when I'm looking at a carport, one with walls. But those 2 buildings back, part of the greenhouse, those I kind of question, how are those built? I mean, is the reason why you didn't get building permits is because you thought they were considered temporary structures, or are they brick and mortar on the bottom with?
Well, they're what I would consider a temporary structure. We did apply for a building permit for back where one of them is, and we were calling it cold storage, because that was just a greenhouse basically for not use for greenhouse plants, so that wouldn't have been a 179 deduction. And then eventually we decided we needed that space to grow plants, and so we used that for a greenhouse. But yeah, I wasn't aware. We went through this many years ago in early 80s on a tax fight, basically. We had a greenhouse set up that cost $600, and it was assessed at $8,000. And at that time, we went through the temporary structure and all that, and I thought we were good. I mean, the assessment got changed to basically something that was more reasonable, I guess.
Madam Chair, to kind of put this in perspective, the house and the other buildings are pre-1994, correct?
The house, The greenhouse, most of the greenhouse stuff is prior to 1994. And planning office told me the house permit was in 1996. I didn't check. I'm assuming the records are correct. That's probably about right. But originally, we had a mobile home on the property. We applied for a permit to get the mobile home. We applied for a permit for the house. We applied for a permit for the deck. I applied for a permit for that cold storage because that was not related, that was not agriculture. So it's not like I've been trying to hide something.
Right, so you've had many permits before this, you just didn't know on the carports and the
Carports
greenhouse.
and, yeah, the greenhouse.
Madam Chair, I move that we let him get his garage started.
Motion by Farabee, is there a second?
Second.
Second by LaCroy. Any discussion?
Well, you know, I don't mind doing that, and I would agree with that. As long as the planning department straightens it out with you what you need and what you don't need, and what building permits you should have had and which ones. But I'm afraid what's gonna happen is, they'll come down to, you needed 2 or 3, and the next thing that's gonna happen is, you're gonna come in and ask us, hey, you know, I don't wanna pay that penalty either, I shouldn't have to do that. And you know, I don't wanna do you a favor if you're gonna turn around and come back and do that to us. I guess that's my feeling.
Scott, any answer to that?
I guarantee
I
you,
don't know what any penalties would be,
a lot.
so I don't know.
Madam Chair.
Commissioner Fairclough.
I'd just like to reiterate what he said, because that will happen. I mean, what Ron said is, once you guys get things all figured out and figured out the building permits, there's gonna be penalties and fees and so forth, and I'm probably on the same line as him. I've kind of changed my mind on relinquishing those
Well,
penalties and fees.
If there's penalties, I guess there's penalties. I'm just trying to get this straightened out.
Thank you, Mr.
And I guess we can vote on that at the time it comes around.
Well, but just to make sure we're all square, as I understand it, there's one, that carport is the only one that's out of compliance at this point without a permit, is that correct?
No, the other one doesn't have a permit, but it's, I guess the one was out of compliance for
Got it.
not having a permit plus being too close to the property
Yeah,
line.
the one on the bottom to the left, that's the one that doesn't meet the setback. So he was willing to move it
The
to
other
meet
one
the
is
setback.
to the right, and it meets the setbacks. So my understanding is I'd have to get a permit for that also.
So there's 2 carports?
Yes.
For me, if there's all the fees paid that need to be paid, then I'd be willing to give the permit today for the others too. So you need to pay all the permit fees from what you owed before, and then this permit, and then start work instead of, start work and then decide later. Or is that not gonna work because he wants to start right away and you guys aren't ready, Cassie?
They're not ready without the stuff.
How long would it take for you guys to figure out, what's gonna happen? Because what if he builds the carport and says, okay, I don't wanna do this?
Right. I don't know what him and PJ had discussed in terms of if they're going to meet on site to kind of hash out the permits or whatnot. I believe that the garage that he wants to build, the new one, I believe that he has already paid the fee on that garage, the building permit fee.
Okay.
And if he were to apply for the carport fee, he would have to pay the building permit fee and the penalty fee. But on the new garage, I believe he's already paid the fee.
Okay, so the other fees, you'll come back and inform us or email us that he has paid those, and you
Yeah.
guys have worked with him and found out what is the best solution for moving forward.
Yep, once we figure out what other building permits he needs, then he would have to pay all of the applicable fees for whatever structures we determine have not had building permits.
Okay,
So Madam Chair, at this point, there's 2 carports that need permits.
Yeah, I mean, if the thing to the bottom left and the one to the right of that are both carports, then yes, it looks like he would need building permits for both of those.
Well, then,
So can
there
I
needs to be like 8 or 9 permits that they're looking at, George, not just 2.
Just the 2 car, is it 8 or 9 or 2 carports that need permits?
He's asking you if there's any other permits he needs besides the 2 carports.
That I don't know. Everything circled in red, to my understanding, are the things that are questionable on whether they have building permits, need building permits, et cetera.
Right.
So that's part of what needs to be hashed out with Mr. Licht, is what of those circled things require building permit.
But for now, the only thing certain is 2 carports. The other ones are questionable.
Garage and carport is what we're talking about right now, right?
Right.
I'd like to modify my motion to say, to move for approval for the garage, providing to be issued as soon as he pays the permit fees for the 2 carports.
Is that the seconders?
No, I don't understand, because he's asking for the 1 carport in the garage, and he's adding in another carport.
2 carports when there's 9 different areas that need to be looked at.
Well, that's what PJ Conover asked me to
The 1 carport in the garage,
do at this
and
time,
then sort through all the rest.
and then work out the rest.
Yes.
But the motion, say
And
your motion
I
again.
could certainly apply for the carport, the other carport too, at the same time.
Hold on a second, sir.
that
Tell me, hold on, Mr. Scott.
What I'm
George?
hearing is for sure of those circled in red, for sure the 2 carports need permits. So my motion is to add on the condition to the building permit that he pay the fees for those 2 buildings, those 2 carports.
Are you,
Before the permit's issued, the garage permit is issued.
are you discounting the other permits when
They're
you do
question-
that?
No.
They're questionable.
Okay. So is that your second, LaCroy?
Well, we'll go through it one more time.
I know, I heard what you said, but it's different from what this, I'd like to hear the staff's report on this
Okay.
before I'm okay with that.
Brittany?
Madam Chair, my understanding, because I talked to PJ before he went on vacation about this, he submitted his building permit for his garage, and he would like to get that started under construction. Because he has other violations on the property, PJ can't approve that building permit unless he addresses all of the other violations on the property. When PJ had met with him, and when PJ had discussed it with me, and then in writing his memo, in order to bring, just to start the process, and because that 1 carport is not meeting the setback, so technically he's in violation, and you'd require a variance for that one. My understanding is that you agreed to move that carport to clear that violation, so he would need just to be issued at this time, his building permit for his garage, so he could get started on that work, and then so he could move that carport to bring it into compliance. PJ did meet out there and walk the site. They wanted to go through and make sure to verify what other of those structures needed building permits and the sizing of it before any other, but this was just a means to get him working and started on what he needed to do and continue to work with staff.
Okay, so are you seconding or not seconding?
No.
Okay, so no second to the amendment. So we're at the original motion.
Madam Chair.
Commissioner LaCroy.
The only reason I say that, George, is because I think that one had to be moved, so you're working with that. That's why they brought this carport in, so you can build out the garage. I think those other rest will come back. You know,
I
The
agree
staff
with,
just told us everything else is questionable. The only thing,
they're gonna work on those, but the carport that was in the right of way is gonna get moved. That's why you're doing the building permit for that, and he wants to build the garage. So I'm okay with those, but to go off on the fly on the rest of them yet, I guess I'd like to do them all together, or get them all figured out, and then, you've been out the property and looked?
the problem is timing. One of these days, snow's gonna fly. And believe it or not, and just an aside, my buddy down at Deerfield Lake said it was white 2 nights ago, white already. The ground was white. So reminder that winter is just around the corner.
He
This,
did,
this man wants to get started with his garage.
Yeah,
yes.
I'm okay
He can
with
start
that.
with his
And I
garage.
think he's got good faith that we'll work out whatever with, you'll pay the permits for whatever, right?
I'm more than willing to work with the planning department.
I'm okay with your original motion.
All right,
Okay,
fine.
so
Thank you.
we're at the original motion with no amendment. All in favor, say aye.
Aye.
All opposed, motion carries.
Thank you.
Thank you.
Thank you, sir.
When would I be able to get the permit?
Next is Mr. Kraft here now?
Do it now?
They said it too.
Mr.
I
Kraft?
have the exact measurements on where it is.
Okay, good, yeah.
Yes.
Okay. Mr. Kraft, come on up.
Then I'll have it better.
One of these days.
Yeah.
There's car parts all over.
This is the trust land funding issues for Bennett and Jackson counties. Mr. Kraft,
Appreciate that. I suppose you have to use your microphone, not used to that.
go ahead and get right by the mic, Mr. Kraft.
Sorry for being a little late. I don't know if they explained to you why, but
I do.
we'll just let it go at that. Anyway, this is a big subject that I've been working on for over 10 years now, and I'm going to try to minimize it. And I'm going to kind of go to 4 separate points, the current status that we're in now and how that's impacted our law enforcement, and finally 2 phases about what we can do about it. Bennett County has severe budget problems right now. We're facing a real crisis in that a couple of years ago, we did an opt-out. And the opt-out runs out for fiscal year 19. So next summer, we're going to have to renew. And we're not quite sure where the public stands on that. I think they'll go along with us again because they want to preserve their autonomy. But some people are not quite so sure. And the issue is if they don't go through with the opt-out for $350,000, that the county will probably bankrupt in a few years. We have some reserve monies left that could probably carry us through the first year and maybe part of the second year after that. But after that, there's a good potential that we could bankrupt. What causes the issue in Bennett County is that about 1/4 of the county is Indian trust land. And I want to make it known right off the bat that this is not a tribal issue, it's not a racial issue, it's not a discrimination issue, it's a money issue. But half the population of Bennett County lives on that piece of trust ground. And that means half the population comes to the county for county services, but they don't pay anything into the county treasury. The amount of money that Bennett County operates on from taxes is about $1.3 million. Our opt-out is $350,000, which is about a 1/4 increase in our property taxes. We have a population of 3,500 people. We only have 860 taxpayers, albeit people who live on taxable land and don't own it, they pay taxes through their rents or whatever. But these people that live on the trust land aren't required to pay taxes because it's federal government land held in trust for their use, and the federal government encourages them to use it and to live on it and provides funding for them to build houses, infrastructure, and everything to make life possible on the trust land. The issue is that we have to build the roads to access that trust land. That becomes our responsibility. And when these folks come to town, we provide all the county services that every other county provides. And we're just running out of money. We hit it on both sides in that every time a piece of land goes into trust, we lose that trust money or that tax money, and then people come in and live on that land and they want county services, and so we're being squeezed. I compared us to Hawken County. I compared us to several counties, but I use Hawken County as an example because they have a similar population and a similar tax base, but they don't have any trust land. we take their entire population and divide it into their budget, and they have about $700 per person to provide county services. If you take our population and divide it into our $1.3 million, it's only about $350 per person. It would be like if all of a sudden you found out tomorrow that Pennington County, that half the people in Pennington County are now living on government land that generates no tax. And what would you do? And this is the squeeze we're getting to be put on. I've been trying to talk to our congressional people about it. I've had little luck, and I'm here to talk about if you guys can help us get the congressional interest that we need. The problem is mostly in law enforcement, in that we have a lot of unemployment. A lot of Indian people move onto these trust lands with government help, but there are no jobs available in Bennett County. We're an agricultural county. The ranchers pretty much take care of themselves. They hire a few people, and if people are willing to work, they don't care who they are, whether they're Indian people or white people. All kinds work on the ranches, and the same thing in town. The businesses in town hire Indian people and white people alike, depending upon their skills. But the problem is that we don't have enough jobs all the way around, and then the skills diminish with a lot of folks that don't have enough skills, and when there aren't enough jobs, those people fall out of the system.
So, Mr. Kraft, today you are asking us to do what for you?
Well, let me, if I can just have a couple more minutes, I'll get to it. I'm asking you to help us talk to our congressional people.
Okay, and your letter you want us to do a letter for 4 specific inquiries? What are those 4 inquiries, sir?
Madam Chair, he asked to continue his spiel, and I agree with that.
I know.
Anyway, I guess maybe the
Still do a
easiest,
spiel, I guess I'm looking for what the bottom line is.
he's getting there. The easiest thing I think for me to do here, explain that if we go bankrupt, I don't know how we dissolve. There are statutes available that allow counties to dissolve on their own. If a bankruptcy court could dissolve us, I don't know, but the statutes don't talk about that. But once we dissolve because we can't pay our bills, we go to the governor goes to the legislature takes us and assigns us to another county. That's the way the statutes write up. My guess is they would not attach us to Jackson County because they have less of a budget than we do. My guess is they would attach us to a county with a big enough population to be able to absorb the expenses and spread it out among a bigger population. And I don't like saying it, but I think you're it. And so I think it's a problem that's going to come your way if we just kick the can down the road and don't do anything about it. And so I'm trying to be preemptive here and get us to go to the congressional people and get an opportunity to talk to them. I'm in a small county. They don't really care about me. I'm hopeful that you're in a bigger county. You have more persuasion with these people when they come to town, and maybe we could all get an opportunity to sit down with them so our problem doesn't become your problem. And I know it's hard for governments to do that. They always like to wait until there's a crisis. But if we were to dissolve and the state would try to rearrange counties, it would create a lot of chaos in the state, and I think it would tear the social fabric of western South Dakota apart. And the worst part of it is that it would not solve the problem. No matter how we restructure the counties, the cost of providing services to these people will fall on the local property taxpayer. And the real issue is that this is a responsibility of the federal government. I don't know, how many of you have read the 1831 Supreme Court ruling in Cherokee Nation versus Georgia? I have some copies here that I'll leave with you, in case this hasn't been amongst your recent readings. And there's one for the public here, too. Okay, thank you. This is the legal basis for, I'll leave one here in this place. This is the legal basis, I think, for going to the federal government. On the second page, I think it is here, let me open mine. Yeah, on the second page, you'll see some portions underlined where it talks about the tribes being determined as sovereigns or nations. And the first part of it there, they may more correctly perhaps be denominated domestic dependent nations, and that's dependent upon the United States. Their relation to the United States resembles that of a ward to his guardian. This is written 1831. Political correctness was not an issue then. They look to our government for protection, rely on its kindness and its power, and appeal to it for relief of their wants. And so when they appeal to the county for their wants, they're not appealing to the right people. The federal government has the responsibility to provide that. Now, they can't provide county service, obviously, but they need to pay us, to reimburse us to provide that. Otherwise, our county goes broke. Again, this is the basis of it. I'd like to go to our federal government and talk about this issue of trying to help us, help local counties survive. Tearing them apart is not in the best interest of South Dakota. We continue to weaken this state because eventually these opt-outs just get bigger and bigger and bigger and bigger with no relief in sight. And eventually they'll begin to impact property values. When the taxes get too high, property taxes will be impacted. If you want to look down the road 40, 50 miles or 50 years, you could see the impact that agriculture may not be able to survive if the tax base is too high. And it impacts the whole state. That's really looking down the road. But this is a problem that's not going to go away. And we need the federal government involved in it. And so I guess that's, I talked to the governor about this, and I talked to the state legislature about it. I have, when I talked to the governor a few years ago, 2013, so I think I got these all clipped here. I wanted you to have copies of these too. So I asked the governor, I said, will you help us if we ever fail? He specifically says, thank you. You'll find it in there toward the bottom of the page.
Just reading that.
But no, they won't. They don't think the legislature will do it because of the precedent that is set.
So have you went to any other counties or anything and got letters from them before, sir?
Yes, I've been to the South Dakota Association of County Commissioners, and I've been working there for 10 years. The problem I'm running into a lot is apathy. The counties that aren't in real trouble yet tend to don't want to be bothered right yet. And I think what you have to do when you look at rural counties, and I can see it in my own, is that the commissioners are ranchers and farmers, and they have their own set of problems. And this issue is kind of beyond where they want to go with things. They don't really understand it. The only reason that I get involved in this is that I was a federal employee for 35 years, and I was a project leader for the Fish and Wildlife Service. And my authority was only 3 places down from Washington.
Right.
And I dealt a lot with the federal government, and I know how it works. And so these guys are happy to let me do this.
So the South Dakota County of local governments, they supported or did not support?
They support it. They've put one of their position papers of positions that they support it. The governor supports it. He has sent letters to our congressional people back the first time I talked to him. And but I think he needs to be nudged more.
Right.
to,
So do you have a sample of your letter that you would like us to look at today?
No, I didn't write up a letter, per se.
Okay.
What I'd really like to do is, this afternoon, I'll be going over and talking to Quinn Neff.
Okay,
And I've spoke to Senator Thune once before. It's been quite some time. He called me on the phone. And, the typical thing is the federal government says we don't have the money. And, I told him, I said, Senator, I understand the government spends $100 billion a year in foreign aid. A lot of it going to countries with dictators that don't even like us.
right.
Can't we cut that by 5% and have money to take care of local governments? And he said, I suppose, but getting it done is the issue, say.
So what is your intention today for us to do, sir?
Well, I'd like to get some sort of commitment that you help me. That we could sit down, maybe we could get together at the association meeting or something like that and take a little time at the association meeting. And in the meantime, if you know of other counties or other people that would be of interest in this thing and willing to make a bigger group out of it, maybe we can have a meeting of some kind at the association meeting and build a strategy about what we really ought to do. Because I can't do this alone.
Yes, I would like to see a letter that you're wanting us to look at or something of intention of where we're going with this before I decide that I'm in
All right.
support of it.
I can email one up.
That's just my opinion. We'll go ahead and ask the board if they have. Board, any discussion on this?
Oh, I have. Are you on the convention agenda or anything? Have you gone that far?
I was on it a few times before. I served for 8 years as a commissioner in Bennett County, and I was chairman for those 8 years. And I spoke to the group a number of times up there. And then I got out for 2 years, and now I'm back in again. And so since I just came back in last January. And so I found out during my time that I was out, the association really didn't want to have a lot to do with me. I mean, they said, yeah, we support and agree with what you're doing, but if I wanted to talk to somebody, I had to lobby them in the hallway. They didn't give me time of day to talk to anybody, so I had to really start that process over again. And so I didn't have time for this year's agenda, and so it'd have to be a thing where we could talk to Bob Wilcox and see if we can set aside some time somewhere and just start the ball rolling.
I think you're absolutely right that, because I'm on the board of directors and we've talked about it and we talk about it and we support Bennett County but don't know what to do next, It's a bigger problem than we know what to do with, I think, is the problem. Because you can go to your legislators and you're right, they don't do much. And
Well, I think more people need to go to them.
well, I agree, and I think that you need to get the whole association behind it. That will probably help some.
Well, they said they would.
But what we run into, and we've run into here, is we want a tax on alcoholic drinks. We got a major problem with it, and that's why our jail's got 600 people, 550 of them because of alcohol. And guess what? We can't do it because 75% of the counties in the state don't care. They don't have enough alcohol sales that it makes any difference to them. Well, we're only going to get $3,000 out of this, so what the heck? And that's what we run into. I think that's what you run into is a lot of counties don't have the problem, and they don't particularly,
see it yet.
don't see the problem. I won't say they don't care, but they don't necessarily see the big problem that you guys are having. But I would be more than happy to, during the convention, to meet with you and whoever else Bob can line up. But I think it needs to be some joint thing with all the counties saying, we got to do something with this. But
Well, I've been wanting to go to the WIR meetings and meet the other counties from other states because I have spoken to some of them. I've talked to Madison County in New York, and they have a similar problem there, but they made the mistake of not going to their governor, and they actually got Senator Schumer to write some legislature for them, but their governor shot it down because he didn't support it because they didn't go see him.
That's why I made it a point to go see the governor and get him on board before, and I went to the legislature and they put together a resolution that they voted on. Only 2 people out of the House and out of the Senate voted against it of support, but it's just support so that if we go to the federal government, those people will say, yes, this is real, and this is a real problem.
Any other discussion from
Madam
the board?
Chair.
Commissioner Croy?
Mr. Kraft, you know, I understand and I praise you for your work and time that you've put into this. You know, but at the Black Hills area of commissioners, you know, when we're doing some of our stuff, some legislators made it clear, you need to give us something to vote on. Give us the answer and give them something to vote on. That's why I was kind of curious, you know, when we've talked on the phone, I mean, we can do a letter of support. And we can talk, you know, when any chance we get, we can talk to these people
Yeah.
and explain to you, but I'm kind of trying to figure out where our limitations are, or what you're expecting us to do. Because, you know, as I said before, we have limited access to the legislatures and the senators just as
Cranking
much
out
as
a
you
letter's
do.
not gonna be a problem. I'm sure I have one in my file that I
Sure.
wrote to someone else. And all I have to do is modify it, and I can email it up here tomorrow or the next day.
Yeah, that's why I was at, you know, like Ron was saying, at the convention, getting a group of people together and figuring out. But I mean, I guess you put more time and effort into this than anybody else we know of. What is the steps that you need to take? Is it with,
Well, I'm
you
looking
know, the
at,
legislatures will support you. You said I didn't know that. You got the letter through there. What other things is it specific that we can do to actually help you besides just promote?
I think I can't be alone in talking to them, because I just simply don't carry enough weight at my position. And I need the position of people from more urban and more population centers, because the more people there are involved, the more interest those folks take. And like I said, I think if we kick it down the road, eventually it'll become your problem.
So you want a letter of support from us, and then you'll send us that?
Well, send something perhaps to the senator or congressperson and ask them if we can sit down and talk to them about this. And I'd like to have you with me.
I'd be more than willing to
And
be
do it,
there.
instead of trying to do it myself, because it's very difficult. I don't carry the weight of enough population to,
So
To
if
get
we
their
want to
interest.
be involved in that, do we have to make a motion, or can we just say, what, Ms. Hawley?
I guess at this point, it'd be my recommendation to have Mr. Kraft send me some information. I'll get it on Pennington County letterhead. We'll put it on the September 5th Board of Commissioners meeting for formal approval. And then the board can move forward with, we can either send it out to all the congressional delegation from there. We can set up appointments with them. We can go from there, but at least to have something in writing formally approved by the board.
That'd be okay with you, Mr. Kraft?
yes, ma'am.
Okay. We have a motion?
I have one more thing. You know, you talked about New York. Have you gone to other states? Because, you know, even if the entire state of South Dakota does, it doesn't mean much. You know, even goes to Congress. Yes, we have 2 senators. We have 1 out of 430 representatives, you know. So, I mean, how about California and New York? Do they have the same problems?
Like I said, the people that don't have the problems don't tend to want to
Yeah.
get involved. I did talk to one of the Board of Supervisors in Napa County, California, and she was very interested in it for a while. But I don't know, she stopped returning calls and faded away. I don't know what became of her. But Napa Valley, California had a slightly different issue in that it wasn't that they didn't have enough money, it was that there were casinos and things being built on tribal land, and that competed with the ones on deeded land, and there was a big disparity there, and that was their issue.
George, did you have something?
No, I was going to ask Mr. Buskerud, did the association, since you've been on that board for a while, ever talk about job owning our congressional delegation on an issue like this? To To me, I hear what he's saying, we need to jawbone them. You can, there's so much paper floating around anymore that, how many people even read so much? But actually getting him, eyeball to eyeball and jawboning, is that?
That's tough. That's tough.
Okay,
You can get with their people that represent them in the county, but to talk to them face to face is getting more difficult.
But if the association of the directors had a delegation to talk to, or whether one-on-one or all three of them at the same time, it'd be best to get it up on their scope. I hear what he's saying.
Oh, yeah.
And he's not the only county. Jones, I imagine Jones is probably just as bad a shape, or getting close.
Yeah, Jackson
The
County
other thing we probably need to do.
Excuse me, Jackson County, yeah.
Is to get it in front of NACO. We belong to that, National Association.
I've been to NACO, they say that they're talking about it, and I've sent them lots of information. I even have a document which I may bring to you, which will pretty much lay out the plan that I sent to the appropriate subcommittees, committees and subcommittees in the Senate and House, and I've talked to representatives of the chairman of each one of those, and I sent it in there, but it's a matter of whether it gets on their agenda or not. And I gave that same stuff to NACO representatives, and if it ever comes up, I think they'll lobby for us, but I don't think they will until it comes up.
So Board, what's your wish?
Before we finish, to me, to convey to our congressional delegation that this is a real problem. It's not just nobody whining, it's a real problem. It's just around the corner, and to me, it's the Association of County Commissioners and the directors. And I've never been in the board meetings, so I have no idea what transpires at those meetings, but.
Well, I'll bring it up again at the convention and see what we can get done.
Yeah, I
Want
appreciate
to do that
I
first, is
would.
bring it up at the convention and then
No,
go from there?
no, I mean, if he wants to send us some information.
No, I'll send some stuff,
Yeah, I think. we
I
need
may
to do
send you
that,
the
but-
same stuff I sent the subcommittees.
Okay, is that what the wish of the board is?
Just before you leave, I should know where Douglas County is, and I don't, but $1,299 per person, that's what their funding is.
Who's?
You got Douglas, on your handout here, Douglas County, and I should know where that is, but I don't.
Oh,
Douglas is down southeast, south central part,
yeah, do they have trust land?
Lake Andes maybe, somewhere in there.
Well, you used, on your chart, you use illustrations of
Oh.
the funding, like Harding County is 1,039.
Well, Harding County gets all
I
that.
understand,
oil money
yeah.
up there.
Yeah, I know where they are, but the contrast, the money that per person that the county has for services is about threefold in Douglas County compared to what you folks have, so. It's real, anyway, I appreciate that, and I totally agree, and I think we need to somehow get the people in power enthused about working at the issue.
Well, I think that's where we need to go. What I'd like to see happen is impact aid, like they have impact aid for schools.
Yeah.
Use that as a model, so it's because it's based on population.
Okay, guys, Busker, Hall,
Let me hand out one more thing. I did a little synopsis.
That's gonna be tough.
what's the ruling on this, guys? We need a motion.
Thank you.
Do you have a motion?
Out of a book that I got from Larry Long when he was Attorney General,
Okay,
and it's kind of just a synopsis of how I'm doing while he was where it is.
somebody give me a motion.
Well, I thought you were talking that he would send some information to Holly, and Holly on the letterhead.
Alrighty.
Well, I'm not sure the motion is even appropriate. There's, all this was a briefing. I mean, at the
Yeah.
agenda,
What we'll do is, if he sends Holly some information, guys, what we'll do is, he can put it on the next agenda at what that motion is and what he needs to have, if we support or not support that. Is that okay with the board?
this is just informational briefing.
Yes, I understand. We're not gonna, he's gonna bring something forward, George Shore, so we're not gonna have a motion today. Thank you for coming today, Mr. Kraft.
Thank
We
you for
appreciate it.
having me. I appreciate your help.
Okay. Okay, board, we are on item 19.
And Madam Chair, if I can, just before your total budget, Bennett County, like 1.3 million?
Yes,
Your
without the
total-
opt-out.
Total budget, including the
For
opt-out.
the county,
Yeah, for the county.
not taken out for schools and all the rest of that stuff.
The county budget.
Just what the county has.
Thank you.
Thank you, sir, for coming today.
Thank you for listening.
Items from chair and commission members. Mr. Buskirk.
Oh, I attended a meeting of the Association Board of Directors, and I got some information on their budget and some resolutions that are going to be in front of the convention. But I think did you get the resolutions?
I did. Do you want those on the next agenda?
No,
for
I don't
board
think they got to
action?
be on it.
Okay,
And that's what's going to be on there, so.
I'll
if-
make copies for everybody.
Yeah, if there's questions, they're pretty straightforward, so. And I'll give you a copy of what the budget is for the association. Other than that, that was about it. Yes, his stuff has been brought up before, but him and Han don't know what to do about it.
Yeah. That's what, when I had conversation with him on the phone too, that's what I was going. He went pretty far up, and the work he's done is amazing.
Yes.
You know, so you gotta be pretty amazed at how much and how far he's got, but I just don't know how to help him either, just from listening to him.
We're going through that ourselves. Look what's going on with Susan, and, I mean, there are questions that the government doesn't want to deal with.
Yep.
You know,
Well, they put it back onto the counties or the cities and just, yep. Mr. Buskard, anything else there?
No.
Okay, Commissioner LaCroy?
We're doing reports or?
Yep.
Okay. Well, I attended the Guiding Council for Collective Impact a couple of weeks ago. Some things have changed hands. Liz Hamburg has taken over the reins and taken over for Albert Lindman. And that was the plan with Collective Impact from the beginning, that Albert would be the one that just come in, start it up, and get it going, and then we needed to turn it over to local entities, and Liz Hamburg with Black Hills Foundation is who's taking it over, along with the foundation has hired Charity Doyle to take over, trying to facilitate and look through the numbers and manage for the things that they're looking at doing. That's about as much as I can report on that right now. I would like to take a minute and we got a note in our book from Custer County Office of Emergency Service. I would like to take a moment to read that
Go ahead,
letter
sir.
into public. Excuse me. The letter comes from the Custer County Office of Emergency Services. It's addressed to Commissioner Hadcock. It says, on behalf of the office of the Board of the Custer County Commissioners, I wish to extend the heartfelt thank you to the Pennington County for the recent mutual aid support in the town of Fairborn. While this was a catastrophic fire, with most assurity would have turned into an, I can't even pronounce that,
Apocalyptic?
there you go. Thank you, George. Event without the assistance from your county. The success of our collaboration, mutual agreements, especially the realm of the search and rescue, fire suppression, have proven itself to be time and time again. With the obstacles facing our volunteer services, it's indeed refreshing to be able to rely on the synergies between our two counties. For over 2 decades, I have had the distinct pleasure of working with your offices of emergency management and fire administration on a frequent basis. The consistency, professionalism illustrated by these entities is not only a tribute to the first response community, but to the example for all of us to follow. Sincerely, Mike Carter, Director of Emergency Services, Custer County. I just wanted to read that into record for that, and I thought was pretty amazing. You know, they're talking about the teamwork and the working together with our areas, and it's showing that there is some appreciation there. That's all I have to
Commissioner
report.
LaCroy? Commissioner Fairby?
Nothing.
We did have a city-county meeting, and we are looking into South Valley with Dale Tech, engineer, or, what's his title now? Public Works Director, and Tom Wilsey, our Highway Department for South Valley. So we're trying to figure out how we can close that donut hole or do something different in that area. We also talked about the mayor has redone the TIF reconstruction on it, on that TIF resolution or whatever you want to call it. And so he's got some good things going on the TIF for affordable housing and some other things that have been problem areas for the city. He also said Ziggy's is moving forward for the Hope Center. So they'll bring out their information and stuff later, but we appreciated that because we do have the fairgrounds in that area, so I appreciated it. Anything else? I think I'm good. Anything else from the board? And if not, let's go on to approval of the vouchers.
So moved.
Moved by LaCroy,
Second.
second by Buschard. Any discussion?
Yes, Madam Chair, just for the record, $3,345,111.63. That's about almost 3 times the total Bennett County budget. Obviously, I'll be voting no again. Thank you.
Thanks. All in favor, say aye.
Aye.
All opposed?
Aye.
Motion carries with 1 no from Commissioner Fairby. Items from the public? There's no public left. Executive session, we already had, and so a motion to adjourn, please.
That would be my motion.
Motion by Commissioner Buschard,
I want to keep going.
You can, though.
Oh, go ahead.
You can't
George,
just
you
call
can
it home
second
when
it?
you're
Oh,
done.
excuse me, second.
second by Commissioner Fairby. All in favor, say aye.
Aye.
All opposed, motion carries.